Very good evening, students. Good evening, everyone. Okay, any volunteer, please confirm about the voice and the video, and I'll start the session. Okay, thank you very much. On that note, let's begin with this class. So, first of all, I welcome each one of you to my class on the case laws of arrest. So let's start with my brief introduction first. My name is Sandeep Khatri. These are my areas of specialization. As you can see on the screen, the constitutional law, the criminal law, commercial law, family law, jurisprudence, and law of torts. Students, I have shared the link of my profile of Unacademy, so make sure you follow that to get all the updates about my special classes and my plus courses. I've also shared the link of my Telegram channel where you can connect with me and ask questions related to your judicial preparation. At last, I have mentioned my code, that is Khatri10, which you can use to get a free access of all the special classes available on Unacademy app, and also to get 10% discount on all the plus courses. So this was about me. Now I request everyone, please be attentive, and this is going to be an interactive session. So the moment you feel you want to ask any of the question done related to the CRPC, feel free to ask your questions in the comments. So now before starting the session, if you have any questions in your mind, you may ask in the comments and I'll answer accordingly. Thank you, Sumati, for clarifying that. Sure. So let's begin with this class, students. When it comes to the concept of arrest, this topic deals from section starting from section 41 till section number 60A. So this is what all the relevant provisions of arrest are. Now coming to the landmark judgments, the first judgment which I can think of, the most important one you can say the landmark judgment when it comes to the concept of arrest is the DK Basu case. Now why? Let's first do understand this. Why it's a landmark judgment? Because the Honorable Supreme Court of India has given certain guidelines in relation to that, in relation to the concept of arrest. So that is why it is considered as one of the landmark judgment. Now, what is the citation for this case? This is famously known as DK Basu case. So the complete citation of the case is DK Basu versus State of West Bengal. 1997 Supreme Court. Now coming to the guidelines, students, what kind of guidelines usually came in this case? The very first one, this one is in relation to the officer who is uh, who is doing the arrest. So the officer whosoever is doing the arrest, he must have the visible identification. Usually you see when there is a police officer, there's a badge on his chest with the name written on it. So there should be a clear mentioning of the name of the officer whosoever is making the arrest. Okay, ji? So that must be completely accurate, that must be visible for the identification. Okay. Coming to the next one. Second one, memo of arrest. The second guideline in DK Basu was key that the police officer, whosoever is, doing the arrest, he should maintain the memo of arrest. At which place, at what time, in what condition, all the important details, while doing the arrest, all that information must be included in the memos. So that memo must be maintained by the police officer while doing the arrest. The third one, call to friend or family. So the next guideline was once the person has been arrested, then in that scenario, that person must have all the rights to call, at least make one call, so that he can inform his family, friends, or relative. Any one call is allowed, in which he can actually informed to his loved ones that he has been arrested, so that they can start they can start consulting the advocate, or they can start the process of the bail. So that is also the right of the arrested person. And usually if someone is not from the legal background, that may not know about this right. So it is also the duty of the police officer to tell the arrested person that, see, you can make a call to any member of your family, and so that you can actually inform that person. Okay. The fourth one is medical examination. Now, what is the role of medical examination here? See, students, when it comes to usually the image of the police, that the police may use a third degree, or police may use the violence on the arrested person. So that's why if there is a medical examination, if there is already, if the arrested person is already injured, that all report must be came out in advance. So that's why there is a concept of medical examination. When you will read section 53 here, so there are basically three kinds of okay, there is basically two kinds of medical examination. One is for the health safety of the arrested person, and the second examination is basically to get the evidences out of the body of the arrested person. So suppose, let's take an example, the accused is of there's one accused who has been accusation has been made for murder, and there is a blood on the shirt of the accused. So then there is an examination of that shirt, so that we can confirm that the blood is of victim only. Okay, so medical examination, you can basically classify it into two parts. The first one is for the health of the arrested person, and the second one is to get the evidences. Coming to the next one, the fifth one, right to meet the advocate of his own choice. So that is also in right of the arrested person as per to section 41 clause D. So the arrested person has all the rights to meet the advocate, so he can get the consultation. He should get about his right of whatever queries in his mind. He may ask that to his advocate, and this is basically section 41 D. Okay, next one. Any questions, students, till now? Anyone having any questions? Okay, I'm continuing with this. Now, the next direction was in relation to a copy, and that copy of the memo, okay, plus the copy of the medical examination needs to be sent to the concerned magistrate, so that the magistrate can basically confirm that there is no violation of any of the provisions of the arrest. So he may confirm that. So one of the guidelines was that once the memo has been made, once the medical examination has been done, so all the reports must be forwarded to the concerned magistrate. Moving forward to the next one. All the particulars about the arrest has also been communicated to the control room. So that is also, there is a concept of control room that needs to be communicated, and that is under section 41 clause C. So control room need also to be informed about the arrest. So these are the basic guidelines that has been given in DK Basu versus State of West Bengal 1997 Supreme Court. Now I want to deal with one important question, that what is the impact of these kind of Supreme Court judgments in the practical basis. So let's understand that way. So let's understand this whole concept now with a practical example. See students, when it comes to police, the police has all the powers to arrest without warrant. The police has all the powers to arrest without warrant in all the cognizable cases. Cognizable cases, or you can say when the police got the information about the cognizable offense. The only one thing that you need to keep in your mind is about the credible information. That the information must be credible. You know, usually when you read section 154, that section starts with the term every information. So every information can be made to, to the FIR. But when it comes to arrest, so there needs to be some credible information. Now coming to, if the police officer thinks that he needs to arrest, there is one person, Mr. A, who is basically the accused. Now who is the accused? Against whom some accusations has been made, that this is the one who has committed the offense. So even in the case if he is an accused, he still have some rights. And this person, even if he got convicted, okay, even if he got convicted, he still had some rights. Okay, so in that scenario, to protect this person, he should inform up to his family members that he got arrested. He should there should be free legal aid. Even if he cannot afford an advocate, then the court is going to make someone uh, available for him for his defense. Then there comes to the role of that, if he is an accused, he should be presented before the magistrate within 24 hours. That is as per to section 57. Now the question is, why you want to make his representation before the magistrate, that is also within 24 hours, and those 24 hours basically do not include the time of the journey. Okay, so the sole reason behind this concept is that the role of magistrate should also be included, so that the magistrate can confirm that whether the police has actually make this as a legal arrest. There is nothing, all the duties of the police officer while making the arrest have been performed, all the rights of the arrested person has been exercised by Mr. A. So to confirm this, we do have the rule of section number 57, which makes this concept that you need to represent him before the magistrate. Okay. Any questions till now? Okay. I'm continuing with this. Now coming to, usually before DK Basu, there was a kind of situations that the huge number of custodial deaths were taking place. Okay. And when you read Indian laws, when you read the criminal laws, when you read the Constitution of India, you know, there is, when it comes to death, it should be only but only through capital punishment, not in the custody of the police officers, right? And because there were many custodial deaths were taking place and there was no accountability, and there comes the role of Supreme Court when they passed these guidelines, which basically was the source of the criminal law amendment as well. That there is a role of section 50 clause A actually came into the picture. And this whole concept actually, after DK Basu, when you see that the things actually changed. Okay, the things actually changed. Now there are hardly any cases coming when the police is using violence on the arrested persons. So these are the practical impacts of some judgments like DK Basu. Okay. Done. Now coming to some another judgments which I also like to discuss on this point on the concept of arrest, and this was the next one was Sheila Burse versus State of Maharashtra 1983. Now I'm coming to the next judgment. If you have any questions from the DK Basu, you may ask. The next judgment I am going to discuss is Sheila Burse versus State of Maharashtra. This is 1983. So this judgment was basically on the females, that females should be arrested by a female officer only. The reason is, when it comes to the concept of arrest, there is you need to physically touch the body, and when it comes to physically touch, there comes the role of modesty of a woman, which should not be harmed. And that's why we came up with the concept ki okay, we need at least one woman officer at that point of time. That woman must take the custody of the woman, so that there is no case of any kind of sexual harassment. Okay, so females not to be arrested without a lady constable that has been held in this case. And in addition to that, no female should be arrested after sunset and before sunrise. Now, as we study law, there is nothing which is absolute in law, so there are always exceptions. So, for example, if a woman needs to be arrested at midnight, then in that exceptional cases, the police officer needs to take permission from the judicial magistrate first class. These all provisions you may find in section 46, which is basically arrest how made. Okay, so in a general circumstances, no, the female should not be get arrested at that point of time. But if there are exceptional circumstances, and the police officer is convinced that the arrest must be taken place in the midnight only, then he needs to take permission from the judicial magistrate first class. And if he took the permission, then the arrest may take place. So that's the exceptional case. Similarly, even after the arrest, there are going to be separate lockups. You cannot put both the male and the female in the same lockup, because of obvious reasons. There should not be any kind of sexual harassment or hurt the modesty of a woman. Okay, so to prevent that, there should be separate lockups. So this all was held in Sheila Burse versus State of Maharashtra. This was again a kind of, you can say, a landmark judgment. Okay. Shivendra Yadav, do you have any question? If yes, you may please rephrase your question. Okay. Chaliye. Now coming to the next one. Next case is Joginder Kumar versus State of UP. That is 1994. And in this case, basically, Supreme Court held that what are the rights of arrested person? If the person has been arrested, what are his rights? So if you got a question that what are the rights of arrested person, then Joginder Kumar versus State of UP is one of the landmark judgments. Okay, Shivendra. Students, now coming to why Sheila Bursay, okay, why Joginder Kumar was a landmark judgment. First, let me give you the citation of the case, and after that, I'll discuss Joginder Kumar. Joginder Kumar versus State of UP, 1994. So when it comes to judgments like Joginder Kumar, they are basically enforcing, you know, the one of the most important point from Joginder Kumar was that if a person who has no idea about his legal rights, okay, because of any XYZ reason, because he's illiterate or that person has nothing to do with the law, so in that circumstances, it is always the duty of the police officer to inform him about his rights, to inform him that you may call one person, to inform him that you may consult with an advocate, to inform him that there is going to be medical examination. This is the purpose of the medical examination. Okay, so these all are the basically duties of the police officer, which are actually the rights of the arrested person. You know the concept of right and duty. If I say there is a right, so it obviously means there is a duty on another person, and if someone has that duty, then there is a right on someone's. That is basically the right of someone's, right? So in Joginder Kumar, basically that was the enforcing point was this only, that whosoever has been arrested, he should get all his rights, even in the cases if he is not aware with his rights. So let's take another example on this. So there are two kinds of offenses. One is bailable of the one of the classification of offenses can be bailable and non-bailable offenses. Now when it comes to bailable offenses, it is always a matter of right that the person will get the bail. So if it is that kind of an offense, so it is the duty of the police officer to tell them that it's a bailable offense and you will get the bail, which can be from the police station or from the court as well. Okay. So this was basically Joginder Kumar versus State of UP. So we have discussed three judgments so far. So any questions till now? Very good evening, unknown, and everyone, those of you who have just joined. If you have any questions, you may ask. Okay. Now I want to discuss one more case, and that is okay. Let me first discuss the case, and after that, I'll give you the citation. So, this one is again very, very interesting. In all your Bollywood movies, you must have seen that while the police officer is doing the arrest, then in that case, usually handcuffs has been used. But nowadays, the handcuff has not been used unless and until there are exceptional circumstances. The kind of person who has been arrested is of such that the handcuffs are compulsory. But in 99% of cases, in ordinary cases, you will not see that when the police officer is doing the arrest, he is not going to use the handcuffs. So this is again that has been held in one of the case. The name of the case is Birendra Kumar Rai versus Union of India in 1992, and it was held that to make an arrest, the police officer need not to be handcuff the person, and it can be completed by spoken words. So here spoken words means either, like, the one of the famous dialogues from the Bollywood movies, that you are under arrest. Okay, and after that, if the person is ready to surrender himself to the police officer, that is fine. But yes, in the cases of resistance, usually there can be circumstances when the person is resisting, that I am not going to surrender myself. So in those circumstances, the police officer may use the reasonable force while doing the arrest. Okay, and you can also uh, read this concept with the right to private defense as well, students. That once arrest has been taken place, so you cannot use right of private defense, because that is completely a lawful process. So this will fall under section 99 of IPC, right? So that is the exception of the exception. Section 99 of IPC is basically the exception of the general exceptions. So in that case, you don't have any of the right to private defense against the police officer. Yes, if there is any illegal arrest, or if there is any illegal encounter is taking place, then the person has all the rights, and then the person may use the right of private defense. So the name of this case is Birendra Kumar Rai versus Union of India. Versus Union of India, 1992. Done. Done. And in this case only, you can also include that the physical contact is not required. To make an arrest, you don't need any physical contact. That is not something which is compulsory. If the other person is all ready to surrender his. Yes, Sunil Batra, Shivendra Yadav, Sunil Batra is again one of the landmark judgment, right? Sunil Batra is again one of the landmark judgment, which you can read here. Done. Good evening, Shivangi. Okay. Now, anything else before concluding the class? Yes, any questions, students, from your end? Shivangi, Shivendra, any questions? Okay, then Shivendra, I'll conclude the class. So students, this is the link of my profile, my Telegram channel, and this is my code Khatri10. So let's crack PCS J with Unacademy. There's a revamped test series. There is a revamped test series for judiciary learners, and we have a special offering this December, as you can see on the screen. This is the Bihar State Judiciary batch, which has been started from December 8th only. This is the Judiciary Legends UP batch, starting from December 15th. You can get your Unacademy Judicial subscription now. This is the prices for plus and the iconic courses. Students, this is the magazine which is coming soon, Articulate, for the monthly current affairs magazine. These are the YouTube channels of Unacademy Judiciary. These are the Telegram channel of Unacademy Judiciary. And that's it from my end. You all are welcome. So see you in my next class. Till then, yes, it's time to say peace.